Just going to try this one out. So, serious case review for child G from Essex Safeguarding Children's Board. You can get a copy of the review in total from this link here. Should you need to see it, it's also lodged in the NSPCC database of serious case reviews. I'm not going to present the whole review. I'm just going to take the edited highlights, the summary of learning from each instance of the review's work, and some background as well. So here's the background. At the age of 3 months, child G was taken to hospital, found to have a serious inflicted injury which occurred whilst in the care of her mother, known as Mother, and her mother's partner, Mr. A. The injuries were considered to have an enduring, life-changing consequence for child G. That means that they were so significant, possibly in this case, although I'm not sure, it could have been brain damage, but it could also have been damage to the long bones that prevented the proper development of the limb or something like that. So there was some serious injury here, sufficient to make the people at the local safeguarding board say, we really need to review this case because things have gone really badly wrong. So the initial information gathered revealed that at the time of the injury, Mum lived alone but was in a relationship with Mr. A, which had started after the birth of child G. So Mr. A is not biologically related to child G. Mum had another child, aged 3 years old, known as the half-sibling, who'd been subject to a child protection plan in Essex, I think sort of 3 years before. Mr. A was known to the Essex Probation Service because he'd committed a number of offences and been known to other local authorities who were concerned about domestic violence and his risk to children. We'll see some more detail of that in a minute or two. Child G had sustained serious injuries, and there was evidence to suggest that there were weaknesses in the way that the information regarding Mother and Mr. A was shared and acted upon between the agencies. The Safeguarding Review Board was convinced that something had to be done, so on the 3rd of September they commissioned the report that we're using here, the review that we're using here. Mother was subsequently charged with offences, so the coppers got involved obviously. She got a custodial sentence, presumably meaning that both children were put into care of some sort. Mr. A was convicted of 2 offences, one of which received at least a significant custodial sentence, and the other ran concurrently, so that the 2 sentences were served together. Following agencies were involved with Mum and her children and Mr. A providing information to the review via a number of mechanisms, particularly by management review report. So, in respect of Mum, we had local health provider service, so they were doing things like maternity visit, I suppose. There's the local clinical commissioning group who are responsible for the GP services. She lived in different areas in Essex, so she had 2 GP practices involved in her case. Local Hospital Foundation Trust, clearly at the maternity, but also accident emergency where child G was referred and triaged to specialist paediatric service. Children's social care for the whole county, obviously being involved with child G's half-sibling, so they had involvement with their family from before the birth of child G. Essex Police, some historical involvement with Mum and the father of the half-sibling, so they provided report for information purposes. With respect to Mr. A, London Borough Council area, well, we don't know which one, we don't really need to know which one, provided information to report on this review. They'd had an involvement with Mr. A sort of 12 years, maybe 11 years ago, when his child was on the Child Protection Register under category of physical abuse. Mr. A moved away and had no further contact except for a letter when he was in prison, so the child was taken off the Child Protection Register. Although actually that information probably wouldn't have helped anybody because it was the child who was on the register, not Mr. A. Another local authority area, police force, they had considerable contact with Mr. A because throughout the period and for the 5-6 years prior, he'd sporadically lived in this other area, so they provided further information as well. Local authority children's social care, contact with Mr. A in relation to a child abuse incident with another family, and they provided information for the report. So, looking at all of those different sources of information, the reviewers claim to have learned the following things. By reviewing events outside the initial scope of the review, it became clear that actions during this period prior to the incident had a significant impact on the case during the review period. Most crucially, Mr. A had a significant history of violence towards women and children, resulting in 1 child being placed upon the protection register, Mr. A serving custodial prison sentences for violence against woman and child, lack of systems in place for ensuring that all this relevant information was tracked across local authority borders, as well as limitations to the MAPA arrangements. Now, MAPA, Multi-Agency Protection Plan, I think it is. I can't remember. It's a multi-agency protection procedures. that should have been in place. So these the final A there stands for arrangements, which are in place to manage current risk of violence. However, despite some limitations in the process, okay, so the MAPA processes and all those other things weren't working brilliantly, but even though those limitations were there, evidence shows that most significant information regarding the assault on the other local authority area was known to the probation service, because they had Mr. A on their books. They had his previous case history, so the probation service knew how dangerous and risky Mr. A was around women and children. In addition, Mother had been known to have a level of vulnerability and the potential to be targeted by perpetrators of DV. Although there was evidence to suggest that she'd made progress, the assessment had not fully addressed the possible implications of any learning difficulties for service provision. So she's known to have vulnerability to DV, and I'm guessing that vulnerability probably hinged on her learning difficulties. But there might have been other sources of vulnerability as well. The work that was carried out had not addressed all the requirements of the child protection plan that had been arranged around the understanding of her vulnerability. Mum's capacity to sustain change had not been assessed. Nobody knew with sufficient confidence that Mum had a sustainable change in her attachments so that she had resilience to being exploited for DV. And yet the case was closed. Child in Need plan was not specific enough nor focused on outcomes for the child, and the case was closed to children's social care without sufficient scrutiny by managers. So here's the key lessons that we're learning here. We need to develop effective systems for tracking men who are known to be violent. This needs to include proactive information sharing of any intelligence about related activities where they're known to have moved across a local authority boundary. And I would also suggest that probably the same thing would be true for police force boundaries, because that's not always the same thing as local authority boundaries. Importance of robust, fully documented outcome-focused child in need plans. I can't believe we're still saying this in 2015. But a plan that doesn't have an outcome focus for it, it's not really a plan at all. It's just sort of like stuff we're going to do. It's not achieving anything. It's not got an objective. Need to work with parents to understand the implications of any learning difficulty and mental health problems for service provision. So if somebody's diagnosed with a mental health, with a learning difficulty or disability in childhood, just because they grow up and are no longer part of the education service doesn't mean to say that our service provision can just ignore that. We need to be taking it into account. Summary of learning mother's pregnancy with child G. So they did a similar sort of review of the experiences of mum in pregnancy. I won't give you all the detail, I'll just give you the summary here. So during mum's pregnancy with child G, the main issue remained the challenge of effective information sharing across fragmented health system. So we'd not got effective sharing between the police and the local authorities about the risks posed by Mr. A. We hadn't got effective sharing of information from the education system to the health system and to child protection services in the case of the mom. So there's a clear message here. During this period there was an accumulation of events that put together could have been seen as indicative of increased vulnerabilities for the children within the family. Here's a list of the events then. 2 attendances by the half-sibling at a minor injuries unit. Evidence of family tensions resulting in mother being arrested for an alleged assault on her sister. Mum's second pregnancy. Little evidence of mother accessing support outside of the family. So that's like disengagement with service. In these events, they'd been considered, in the light of the previous knowledge of the family, health professionals could have considered referring to children's social care with a request for an assessment of mother's needs and any potential concerns relating to her capacity to care for both of her children. However, information was known to be different. Health professionals at different times and communication pathways between GPs, health visitors and midwives at times of bookings were not used. There were no practice meetings within the GP surgeries where vulnerable patients might be discussed, and although the review has been informed that this is now happening in some areas, Surgery Concerned still reports a lack of effective communication with health visitors and midwives. This is astonishing. This is within a service here, isn't it? Okay. In addition, midwives recorded mother's self-disclosed history regarding previous child protection concerns, but did not explore this further or ask searching questions about the father of mother's child. Although the father was not Mr. A, lack of a practice culture which does not focus on fathers and partners is significant when Mr. A later joins the household. Key lessons from this period. We need to consider whether it's possible to track the whereabouts and activities of individuals with a history of violence involving children. importance of developing and using effective information sharing regarding vulnerable families across GPs, midwives and health services. Importance of systems which enable midwives to access full history from medical records at the point of booking. Now, this is very often couched in the kind of data protection stuff, confidentiality and rights to know and secrecy and things. I think there's a major ethical question to be answered there about why we do that. Need to mitigate the risks associated with no overall lead midwife for each mother. We know that in children's social care, we'd have a lead professional for every case, somebody who sort of holds the case whilst other people have activities within it. But there isn't such a thing in midwifery, which strikes me as a bit strange. Need to ensure a focus on the role of fathers and partners throughout pregnancy during the early years of the child's life. Very much an ignored component of our welfare service response to families with young children. Most importantly, practitioners need to develop respectful curiosity about the circumstances of people they are working with. They need to be asking questions which will help them develop a picture of the whole person and follow up any queries which may indicate a cause for concern. When we think about the same kind of data coming out of the birth of child G up to the point of serious injury, there were a number of issues emerging from this period, particularly in relation to the importance of taking the whole family approach to understanding the needs of parents and children. Health services continue to be fragmented. Health visitor was unaware of the details of the out-of-hours medical consultation and not having a full picture of previous concerns regarding the half-sibling. Neither the GP nor the health visitor had a sufficient grasp of the whole picture to reflect on the number of times that the half-sibling presented to health services, and there's no indication that any practitioner identified the level of mother's vulnerability. These were people who were in regular contact with her and weren't clued into the fact that she had this learning disabilities related vulnerability to exploitation by persons with domestic violence intentions. Within the probation services, there was a similar pattern of insufficient consideration of the meaning of historical information combined with current events. So they knew Mr. A was involved with Mum. They knew there was a child there. They knew there'd been a child protection plan in place for that child, the half-sibling, and they knew there was a new child on the way. But they didn't really join up those dots and say, wait a minute, why is Mr. A involving himself with yet another family that he's already sort of shown himself to be incapable of dealing with safely? One reason for the transfer of the case between Offender Manager 1 and Offender Manager 2 and the over-reliance on verbal information at handover that did not include all the information contained within the records. Can't trust spoken words, you got to read the detail. The devil is always in the detail. Key lessons. Importance of an holistic approach to families, including family needs assessment with health visiting practice. Need for effective information sharing and review of vulnerable families, GPs, and health visitors. Need for thorough review of all records when case transfers between offender managers is managed. Need to consider whether the system for alerting unpaid work supervisors to potential risk offenders may pose to children is sufficiently clear and understood. That's because Mr. A was engaged in some voluntary activities, some voluntary work, I think it was reparation stuff, and his supervisor on those occasions was a useful source of information but hadn't been alerted to the fact that there was something that needed to be looked at. Need for offender managers to consult immediately with their supervisors where information comes to light that a person with a history of safeguarding concerns has formed a new relationship with a partner who has a child. This discussion should consider further information and they should obtain immediately from the offender whether the referral should be made to the children's social care. Rationale for the decision made needs to be recorded. You have to put down the reasons for the choices you made. Need for clarity that consent to share information may be dispensed with where a child is suffering or likely to suffer significant harm. This cannot be said loudly enough. There is no good reason on the basis of confidentiality or data protection if a child or a vulnerable person is suffering or likely to suffer. That trumps all considerations. You can't get yourself into trouble for sharing information under those circumstances if hand on heart you know there's harm or significant risk of harm. Importance of developing skills, confidence of staff working in settings such as minor injuries unit, where they may not be regularly exposed to severe injuries indicative of child abuse. And that's your lot, guys. I hope you had the time to look over that and review the content of this video, and we'll be ready to discuss it when we meet next Tuesday. Thank you very much for your time.